We are on the record in the matter of the city of Wyandotte first, Andreal Rice, 24562 A and B. And counsel?
Good morning, Your Honor. Christopher Shemke, appearing on behalf of my client. This time we consent to the matter being heard via Zoom. As to the arraignment, we waive formal reading. My client stands muted.
All right, sir, your name for the record, please.
Rice.
I'm sorry, your first name didn't come through. Can you repeat that again, please?
Andreal.
Okay. All right, and sir, and good morning, sir. The court will waive the formal reading, enter a plea of not guilty for purposes of the arraignment, and as to bond counsel.
Your Honor, as to bond, my client currently works at Cringe Construction full-time. He lives in Lincoln Park. Pays child support to his two children, ages 9 and 1. It's my understanding he's not on probation or parole, so we would be asking for any leniency this honorable court could determine. I know financially that he is not in a position to post a bond, so we'd ask consideration for a potentially personal bond. Thank you, Judge.
All right, and sir, you reside in Lincoln Park, correct?
Correct.
And you're not currently out on bond in any other jurisdiction?
Correct.
You're not currently on probation or parole anywhere, is that correct?
That is correct.
And where is it you work, sir? What city is that in?
Onya.
And how do you get back and forth from your home to Livonia every day, sir?
Coworkers.
And what's the reason that your license is suspended?
An offense back in 2005.
Okay, actually it's revoked. Oh, that's right, yeah. It shows 2 alcohol-related convictions within a year. And if you're to test today, sir, what's in your system?
I'm clean, so you won't find anything.
Okay. And so, Ms. Blake, does she reside with you?
She's my girlfriend. She has her own residence.
Okay, so I need to make sure so that you're not going to be driving a motor vehicle in the event that you're released on bond. So I was wondering, that's my question, does she reside at the home where you have access to her vehicle?
No, we live in 2 different places. I will not be touching her either.
All right, the court's going to order a $7,500 personal bond. Sir, you're not to possess or consume any alcohol or drugs that are not prescribed, and you are also not to drive a motor vehicle at all. You don't have that privilege. That's a privilege of the state of Michigan. You don't have that right now.
May I ask a question, Your Honor?
You may.
Why was it written in the Constitution that people can travel point A to point B without breaking any city or local laws? Why is that in the Constitution? I'm just confused by that.
Well, sir, I'm not sure exactly why that was because I was not around when the Constitution was written, nor for the intention of what our founding fathers intended regarding that when the Constitution was written. What I can tell you is if somebody is going from point A to point B on any type of road that's open to the public or whatnot, that is what the laws cover. So if you want to use a different word of semantics, whether it's driving, traveling, moving, whatever it may be, at the end of the day, you're going from point A to point B in a motor vehicle without a valid license. Sir, if you drive, that's a violation, not only of the law, but a bond violation. Your bond will be revoked and you will be sitting in the Wayne County Jail until your next court date. So it's strongly encouraged that you do not drive, travel, move, whatever verb you want to utilize, sir, to get you from point A to point B, or point A to point E with B, C, and D in between. Is that understood, sir? Are we clear?
That's cute.
Cool. Let me go talk to him.
Okay. Go!
Hand me my screen box.
Now go. Free. Rah.
Okay, we are going on the record in the matter of the state of Michigan versus Nicholas Lawson, 24564. And appearance counsel?
Good morning, Your Honor. Christopher Shemke, my client. This time we consent to the matter being heard via Zoom. As the arraignment, we wait formal reading. My client stands mute.
Thank you. And sir, your name for the record, please.
My name is Nicholas Lawson.
All right, thank you. And Detective McDonald, your name for the record, please.
Second, Mike McDonald, PD, MICHAELMCDONALD.
All right, thank you. And are you here to address bond today?
Yes.
Okay. All right. And so, Mr. Shemke, I believe you stated that you wanted to waive the formal reading, correct?
Yes, Your Honor.
All right, the court will waive the formal reading. Enter a plea of not guilty for purposes of the arraignment. And the court will schedule this matter for a pre-trial on May 23rd at 9:45 a.m. Counsel, as to bond, and then I'll give Detective McDonald an opportunity to address bond as well.
Your Honor, my client's not on probation or parole. It's my understanding that the altercation happened at his residence. The complaining witness does not reside there. However, if necessary, he can find alternative lodging. He has a friend that he can stay with in Detroit. He has no children. He's gainfully employed at. Judge, I'd be respectfully requesting consideration for a personal bond. Thank you, Judge.
Okay, Mr. Lawson,
Yes, ma'am.
who is it that you would be living with, sir, if the court, if you post bond or the court orders a bond or your release?
I have two options. I can either go back and live with my mom, or I can go live with my friend out in Midtown. I was already in the process of moving out to go live with my friend in Midtown before this altercation had happened.
Okay, and so where does your mom live?
My mom lives on 201.
Okay, and how long have you resided at the apartment on 4th Street?
I believe a year and a half, if two.
Who resided there with you, sir?
Just me, I believe. I don't think there's anyone else on the lease.
I didn't ask who else is on the lease, sir. I asked who else lived there.
A roommate and, well, my ex, but she is moving out, but I can't prove that.
Your ex, is that Ms. Shemansky?
Yes. She's, I'm correct, she's already at her mom's house, but again, I can't prove that to you yet.
Okay, and where does her mom live?
She lives also in Brownstown, in Tele Valley Trailer Park.
All right, and sir, have you ever failed to appear in court?
I'm sorry, what?
Have you ever failed to appear in court?
No,
Are you currently on probation or parole anywhere, sir?
no,
Out on bond, any other jurisdiction?
no, ma'am.
Okay, and Detective McDonald, as to bond.
Yes, Your Honor. Doesn't appear that Mr. Lawson has any domestic background. Within the packet, though, I did include he is registered as a sex offender. I wasn't able to find the CCH on that or the details. I will leave the cash bond up to the court's discretion. The only thing I ask is that the victim did tell me that she's living in an alternate location with her mother. I would just ask that Lawson be prohibited from going into contact with her or the mother. The victim also expressed concern of him coming up to her work, which is the. She specifically asked that the court prohibit him from being there because she is concerned he'll cause some issues with her at her workplace. Those are the only conditions I request, Your Honor.
All right, and Detective Ms. Shemansky has confirmed that she no longer lives at the apartment?
Yeah, she said she was currently living with her mother. She didn't tell me whether or not she has officially moved out completely.
Okay. Okay, and where is it you work, sir?
I work at the, but I work for a different company.
Okay. Well, Detective, I was a bit confused because I saw that registration as well, and it's a lifetime registration, but there's not anything in the CCH. Mr. Lawson, do you have any criminal convictions?
For the CSC2, I was 13 years old. I don't know exactly what it is, but they told me that you can't pull it up, but I do have to go quarterly every year for the rest of my life, yes.
Okay, so that's probably why it's not showing up as a juvenile offense. Okay. That was my other question, because I was looking at your age, sir, and all right, given the nature of the charges in this matter, the concern for the safety of Ms. Shemansky, and to ensure that Mr. Lawson will return to court, the court's going to order a $5,000 10% bond. These are your following bond conditions, sir. You are not to have any contact with Michaela Shemansky. That's phone contact, text message, email, social media, third party, anything of the like. You're not to have any contact with any prosecution witnesses. You're not to enter the premises where Ms. Shemansky resides or where she works there at Marco. You can't even drive by there, sir. So we're in relation, oh, well, we're in relation to the apartment is Ms. Shemansky's, oh, it looks as though it's just.
It's very close. It's just north of the actual apartments. There's a parking lot or so in between. It's probably about a couple hundred yards.
Okay, but given that side of 4th Street's only one direction, well, so, and I asked that because I'm going to order a GPS tether. And so this way, I mean, it may be an exclusion zone, but when the tether is being placed on you, sir, make sure you're communicating with the tether agent. And so that when it's just a second or something, and that shouldn't be a violation, okay? The court's going to order no house arrest. You're not to possess or consume any alcohol or drugs unless prescribed. You're not to possess or access any weapons and or firearms. Do you have any of those at your home, sir?
No, but you said I'm not allowed to possess alcohol with this tether on?
Yes.
Okay.
Alcohol or any other drug that you're not prescribed. Do you have any prescription medication, sir?
No.
Okay. All right, anything else?
How long would I be wearing this tether, possibly?
I can't answer that I can tell you at least until May 23rd. I don't know if that will continue after that or not. I don't know that yet.
Okay. And then you said 10% of my bond, and it's a $5,000 bond, which is $500, correct?
Correct, sir.
And if I paid that off now, today, I can get out of here?
Do you have an extra, $181? And then we can have the tether unit come here and come to Riverview PD to put the tether on?
I should on my card that they have on evidence, and if they don't, I could call my mom and she can bring up the extra money that I need. I have the money for the bond.
Okay, so then the police officers there will coordinate to make sure and we'll communicate with our probation department because they will contact EMS tether so they can come out to the police department, have the tether on, sir, so you're not making the trip down to Wayne County Jail, okay?
Okay.
All right, thank you. Have a good day.
Thank you. Have a better one.
All right, and we are on the record in the matter of City of Riverview versus Gerald Wilson, 222332 and 21799A 24565. And counsel, your appearance, please.
Good morning, Your Honor. Bearing behalf of my client, it's time we consent to the matter being heard via Zoom. As the arraignment, we wait for formal reading. My client stands muted.
All right, thank you. And Mr. Wilson, your name for the record, please.
How you doing, Your Honor? My name is Gerald Lamar Wilson.
Okay, and to be heard, your name for the record, please.
Dr. Michael McDonald, MICHAELMCDONALD.
Okay, you're here to address bond, correct?
Yes, Your Honor.
All right. Okay, well, it's the 24565. Mr. Wilson's in custody on a new matter, and so this matter is up for arraignment, as well as the other matters, because Mr. Wilson has previously failed to appear in court for any of his previously scheduled court dates. And so the court will go ahead and waive the formal reading on all of these matters, enter a plea of not guilty for purposes of the arraignment. And we will schedule these matters for May 20th and then ask to bond counsel.
Your Honor, as to bond, my client currently works at lives with a friend in River Rouge, and he has a 3-year-old son that he assists in taking care of. He's apologetic for not taking care of these other prior matters. However, the prior ones are driving while license suspended charges, not to minimize those responsibilities, but he indicates he will appear at any all future court dates. So I'd humbly request any leniency this honorable court could consider when determining an appropriate bond. Thank you, Judge.
All right, thank you. And Mr. Wilson,
Yes, Your Honor.
where have you been other than the 27th District Court?
I've been working. I have been homeless for the last 5 years. I've been working. I just got a job in Riverview on 4th Street. I currently have a child he just turned 3. I've been trying to figure out my living arrangements for the last 5 years. I've been trying my best to take care of my child and pay these fines off with the courts. I've been trying my best as a man to take care of all my responsibilities, Your Honor. I have not tried to duck them or dodge them at all. I have been trying, and that's why I work and I just became a full-time assistant, and it's a little hard of taking care of my 3-year-old child.
Well, sir, I'm glad to see that you are employed and taking care of that. I have many different addresses for you. I have Inkster, Riverview, and Canton, and now I'm told that you reside in River Rouge.
No, my current address right now, Your Honor, is Riverview.
Riverview, I apologize, Judge. Riverview. That's my mistake, Your Honor.
Okay. Okay, oh, that's okay. All right, the one on 4th Street, sir?
Yes, Your Honor. I live with a friend because right now I'm currently homeless, and I've been walking back and forth to work every single day. I have not been. I work at that's right there on 4th Street in Sibley. It's like right there on the corner. It's like 5 seconds away from where I live. It's like walking distance, like 5 minutes away.
All right, and Detective, I'm sorry, Mr. Wilson, are you currently on probation or parole anywhere, sir?
Can you say it again? I'm sorry, I didn't hear.
Are you currently on probation or parole anywhere?
No, Your Honor.
Are you out on bond in any other jurisdiction?
A bond jurisdiction?
Are you on bond anywhere else?
Are you out
no.
on bond in any other jurisdiction?
No, Your Honor.
All right, Detective, would you like to address bond?
Yes, Your Honor. As far as a cash bond is concerned, I will leave that up to the court's discretion. I do understand that this is not any violent or serious misdemeanor. However, we do have serious concerns with Mr. Wilson showing up for court, considering that this is now his 4th matter with our city alone, and the fact that he has 14 other warrants with other jurisdictions. So I would request a GPS tether so that we can find him and make sure that he actually does appear for court.
Where are the other warrants?
We have Inkster, Garden City, Hazel Park, Detroit, Van Buren, Romulus, Van Buren again, St. Clair Shores, Wesley, Canton.
Sir, here's the concern that this court has. You have a number of warrants outstanding because you failed to appear in court. You have 3 outstanding matters in this court, and now you have a 4th one.
Yes, Your Honor. I've currently been homeless.
Sir, I can understand your circumstances. Have you at any point reached out to the court, whether by phone or by email, to see about rescheduling your matters or what you can do to reschedule the matters?
I just got a phone this year, Your Honor. I have not had a phone or any emails or nothing. Like, I just got this job. I just got a phone, and I've been trying to work my way and take care of all these things.
Okay, sir, I can understand that. But at some point you had vehicles to drive because you have 3 charges of driving while license suspended at 3 different occasions. So whether they weren't your cars or you were borrowing them, You could have borrowed somebody's phone or something to contact the court. Or perhaps you could have had somebody bring you here to see about rescheduling. And you don't show up to court.
And Your Honor, I promise you, I will show up. I'm not ducking the courts. I've been trying to just get my son together and get the mother of my child and my life together, because I really don't have no money and nowhere to go. And I promise you, Your Honor, I've been trying my best. I've been trying. I know what it looks like, but I promise you, I've been trying.
So here's where I'm at, sir. Where I'm at is that I will allow you a personal bond, but you're going to not be released without a GPS tether. So that in the event you don't show up, we know where to find you. So what
Yes, Your
that
Honor.
means is that you'll need $181 so that you can be released today, so that the tether can come out to where you're at, the Riverview Police Department, and put the tether on. Otherwise, you'll have to go down to Wayne County Jail, and hopefully they can have a tether on you within a few days, but I can't guarantee that.
Okay. I can call my mother. If not, I think she's already up here and she's willing to pay the $180 for the tether, so I can go home today.
Okay? The court's going to order a $5,000 personal bond on all of these matters. You are not to be released without a GPS tether. EMS tether will be coming to the Riverview Police Department to have that tether placed on you, sir. If you do not show up on May 20th, you will be arrested, sir, and you will be in custody until your next court date. Do you understand all of that, sir?
Yes, Your Honor, I understand. Yes, I do.
And we're changing the time to 10:45 instead of the 9:45 that I initially stated. You are, sir, you don't have a valid license, correct? So I'm going to order that you are not to drive, and that it will be a GPS tether through EMS, no house arrest. You're also not to possess or consume any alcohol or drugs that are not prescribed.
Your Honor, I don't do drugs.
Okay, good. Then you won't have any problem complying with bond, right, sir?
Not at all. I don't have no problem.
All right, very good.
Yes, Your Honor, thank you.
Thank you, Your Honor.
You're welcome. All right, we are on the record in the matter of the state of Michigan versus Joseph Yates, 24566. And Detective Carr, your name for the record, please.
Good afternoon, Your Honor. Detective Joseph Carr, Wannabe Police.
All right, please raise your right hand. You solemnly swear from the testimony about to give this man the truth, the whole truth, and nothing but the truth.
Yes, ma'am.
All right, thank you. And you may proceed on the warrant.
Your Honor, on May 8th, 2024, about 10:51 p.m., officers John Berry and Tyler Rowe reported they observed a black 2009 Ford Escape with a defective tail lamp traveling in the area of Oak and 23rd. A lead inquiry indicated that the vehicle did not have any valid insurance. Officers conducted a traffic stop and made contact with the driver, later identified as the defendant, Joseph Yates. The defendant was able to produce a driver's license, at which time Officer Berry detected a strong odor of alcohol emanating from the defendant's breath as he spoke. The defendant was asked to exit the vehicle, where a series of standard field sobriety tests were conducted, at which time the defendant failed. Officers then advised the defendant he was under arrest for OWI, where he was cuffed and detained in the rear of a marked police car. Officers further noted that the defendant's 14-year-old son was the front seat passenger of the vehicle when the defendant was driving. The defendant was then conveyed to the station, where he submitted to a breath test, which revealed to have a BAC of .213 and .219. Per lien, the defendant has a prior alcohol conviction in 2021, in addition to having a suspended driver's license.
All right, upon examination of the complaining witness, the offensive charge were committed, defendant, and that there was probable cause to believe defendant committed those offenses. And counsel, your appearance, please.
Good morning, Your Honor. Christopher Shemke, appearing on behalf of my client. It's time to consent to the matter being heard via Zoom. As to the arraignment, we waive formal reading. My client stands mute.
All right, and Mr. Yates, your name for the record, please.
Joseph Yates.
All right, sir. The court's going to waive the formal reading. Sir, you have the following rights. You have the right to have an attorney. If you cannot afford one, the court will appoint one to represent you. In fact, you've had an opportunity to speak to an attorney today. Is that correct?
Yes.
All right, you have the right in the courts, also sign the petition order for court appointed attorney once I have that back. And, for felony matters. And sir, you also, understand that you do have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have a trial by a judge or by a jury, and you also have the right to remain silent. Anything you say orally or in writing may be used against you in court. Do you understand those rights, sir?
Yes.
The court's entering a plea of not guilty on your behalf, scheduling this matter for probable cause conference on May 16th at 10:15 a.m. I hope that works, but that's, I think, not a good day already. I don't have anywhere else to put it, I don't think. And as to bond counsel.
Your Honor, as to bond, my client is gainfully employed. He works at. Those are this mother in Detroit. He has a strong family support system with 2 boys at these sports, ages 18 and 15. Judge, she's not on probation, as I indicated, or parole. I'd be respectfully requesting consideration for a personal bond. Thank you.
Okay, and sir, how long have you resided in Detroit with your mom?
Moved in with her last year because her husband passed away.
Okay, and sir, how long have you been working there in Romulus?
About 8-9 months.
Have you ever failed to appear in court before, sir?
I didn't fail to appear in court. No. Well, once in Southgate, but that's when I was at work and I didn't get the letter in the mail saying when I had to come back. But I wouldn't take care of all that already.
Are you on bond in any other jurisdiction?
No.
Did you end up taking care of your matter in Southgate?
Yes.
That's it, as to bond.
Your Honor, recommend the $500 cash bond in addition to an alcohol GPS tether.
All right, based upon the nature of the charges in this matter and that just 3 years ago, there was a 2.5 years ago, you had a prior conviction for the same type of offense. The court wants to ensure that you're going to appear in court and ensure the safety of the public. The court's going to order a $5,000 10% bond. You're not to possess or consume any alcohol or drugs, and you are to, or unless prescribed, and you are to have an alcohol tether. So are you planning on posting bond?
I'm gonna try to. I don't know if I can come up with it. I was supposed to get my check today at work, but I didn't make it in.
Well, so my question was going to be, sir, do you have the additional $181 that you can pay so that the company can come here to the Wyandotte jail to affix the tether?
I don't have it on me. I can make a call and see if I can get it.
Well, here's what I'm going to say. If you can get it, then I'll allow you to do it that way. If you cannot, then you'll have to have a Wayne County jail tether.
Okay.
Alcohol tether. All right. Any questions? Anything else?
No, Your Honor.
Oh, Your Honor,
Thank you. Thank you for running off the record.
Does that conclude my matters, Judge?
So far.
Well, it could be worse. I could have a jury trial. Oh, too soon.
All right. Have a good day. Have a good weekend.
Take care, Judge.
Calls the case of Alec Jerome versus Eric Cassidy.
They have your Paula. She's not here today. She's on appointment.
All right, Eric Cassidy and Paula Cassidy.
And actually, Your Honor, you did retain a lawyer.
I know. Where is she?
She could not be here today. She needs to go next week, but you know, we're happy to go forward, but she's available next week. Next Friday.
Okay. Go ahead. Your name.
DiSanto, appearing on behalf of Alec Jerome and Caroline Jerome, who are the landlords and owners of Route 270 North Maple. In our summons and supplemental plea, I gave you the numbers that were owing from as of April 15th. I have updated those.
Okay, so
Yes.
Just stop you.
Okay.
Did you receive the answer and affirmative defenses?
In the hallway.
They are substantially the same as what was filed.
So
This was dismissed about.
No, I know.
I mean, I've looked through them. They're not signed And they're virtually the same.
Okay, so
Filed in the case that you dismissed.
yeah, I know. Okay, a couple problems. First of all, you're represented by counsel, they're not here. Okay. That's the first thing. The second thing is, rather than taking a lot of time, I've got another problem with your filing. Okay. You gave a new notice, right? Okay, for 30 days.
Yes.
Right? Like we had talked about.
That was on May 3rd.
Right. Problem is you filed the case before the notice expired.
I knew that that I wouldn't be heard until after that May 3rd date.
I know, but you can't. I follow what your intentions were, but you can't file. I want to say this. You're giving them 30 days to move out. They have to do something before a cause of action arises. So they either have to move out or some way do something. The problem is that you filed the case before their period in time to do whatever you were telling them to do, which was move out.
Paid as well.
Okay, either way, they had a time period on which to do that. I know they didn't, but you filed a case before that.
It wasn't heard or answered until after that date. So you're going to dismiss this again?
I am not going to do that. I'm saying that's a problem I have. Here's the other problem, the other part of the problem. And I'm not sure where it would end up. If I dismiss your case, their case, the case doesn't go away because they filed a counterclaim and a request for declaratory relief and an answer. So I would have one side of the case pending, right? And I wish counsel were here because counsel would understand exactly what I'm saying. So I'd have the one side of the case pending. I'm presuming that then what you would do is you can use the same notice that you have here, you'd refile, and then what would happen is I would have two cases pending at the same time that I'd have to join together.
Okay.
So if counsel were here, I would suggest to her that she not move to dismiss, waive whatever may come from that, and just keep this going and everybody kind of head into the direction that we're going. Okay. But she's not here, so I can't ask her that. So, you said she's available next week?
Yes, she wants to on Friday.
Yes. Well, they're always on Friday. So what I'm going to do is not dismiss your case at this point. Okay, but that doesn't mean next week it might not happen, right?
We still have the case.
Well, right, but I'm just suggesting a quicker way to get,
Around it.
well, not around it, but to get everything moving. And so I'd prefer to give it a week, let that happen, see what counsel says, and then we move. The worst thing that's going to happen is I dismiss your primary claim, you file again. You don't have to wait on the notice because now the notice has expired. And then I'm going to set this other case out until that other case catches up, because that's what I'm going to do for judicial economy. So, got it?
Yes.
I know you don't like it, but it's
You know,
what I have to do.
no, I like whatever you can do so that this case does move forward, because the stalling of it has raised it over now. They want it dismissed because it's over $25,000. Well, that's because they haven't paid anything since September. So.
That is incorrect.
What is incorrect?
Yeah.
Okay,
They've been in arrears.
folks, I cannot litigate this today.
No, I know. I'm not unhappy, and I'm not, I'm very pleased that you are able to create a way forward.
Let's hope. Okay, well, you're welcome for that. May 17th, 2024, what time?
2 p.m.
At 2 p.m. We'll see you guys then.
Just briefly, Ms. Miller did file a very short motion, other issues that she has prepared. It's with your file, and so.
She did what?
She filed,
I know, she gave me a whole tree.
yes.
So what?
On the inside, it lists 5 different issues that she wants to review next time, if you want. And she also filed this. She wants to inside cover that.
Got it. We'll see you guys next week. Court calls the case. Katrina Pimentel versus Haley Wilson.
I'm here. Can you hear me, Judge?
Yes, I can hear you. It's Katrina Pimentel and Christopher Pimentel versus Haley Wilson.
Yeah,
Ms.
it's
Wilson?
actually Karina.
And
I'm
it's
sorry?
actually Hallie.
Okay. Where are we on this case, folks?
So I filed a motion to reopen the matter and proceed with eviction. Last time we were in court, you ordered her to pay, I believe it was, let me just pull it up here.
1035.
1035
Yes.
plus April rent. And she made the payment, I believe it was last week of the 1035, but she still owes April and May rent. And
I can't hear.
because of whatever, I'm here.
Ma'am, you're going to have to stay someplace stationary because you keep going in and out.
I'm sorry. Is this okay right here? Can you hear me
Yep.
good?
I can hear you.
Because of whatever issues she's had with Section A, they have not paid her April and May rent either. So we actually have we are owed the entire month of April and May. We spoke to Section A. They said that they did not receive recertification paperwork from her, and that's why they held April rent. And that they said they would release it, but as of yet, they have not released it.
That would be because they have sent 2 notifications to you about the inspection that they said that you have not responded to, and I did send you the correspondence that was sent.
Haley, we spoke to Section A, and they said that they had trouble getting in contact with you concerning recertification. That's why April rent has not been paid. You sent us a letter, and I have the messages for May, where you said you just received this May 1st for the inspection. That is the first time that I'm seeing that one.
Right, you're saying May. I'm just saying in April, I've got the email from her that says that they released it immediately. I mean, I sent you directly what they sent me. I mean, and they sent on that form is where it says that they wouldn't be doing May's because of the inspection that they hadn't heard back from you. And I can get that paperwork right now.
You muted yourself, so you were saying something and I didn't hear you.
I'm sorry. We the only reason why we even found out about April rent is because we had to get on the phone and speak to Section A for hours trying to get a hold of someone to figure out why we weren't paid for April. And as of yet, they have not released payment for April. They said that the reason why they held payment is because they did not hear back from her concerning recertification, and that normally they would just cancel her voucher, but she ended up getting a nice case manager that said they just held payment instead to give her the opportunity to be able to provide the recertification paperwork so that they can release payments. But as of now, we have not been paid April and we have not been paid May, the entire rent amount. And, you know, as far as last time we were in court, you know, you set the amount of 1035 for her to pay plus the April rent. She just paid that last week. I'm just at the point where I just feel like this is going to be an ongoing issue, and it's been going on for too long. We've been patient. I just don't want to, be back in court again.
I don't have anything that indicates she has a voucher, correct?
Correct.
Have you finished your research?
Oh, yes, and I've got
who administers your voucher?
CMA out of they're like in a 231 area code up north, I believe.
That may be part of our problem. Amy, you have something to tell me?
Refer to the HCD retention team over at SOS that might be able to assist with teasing out the issue.
That's the other thing. I had I filled out for a SER, and my caseworker, Miss Lamar, she sent for shelter verification to be filled out by the landlord and had not received anything.
Okay,
so that
look,
hindered
are you
me.
guys going to sit? Let me ask you a question. Are you guys going to sit here and blame each other about everything, or do you guys want to try to solve this?
I'd love to solve it.
I mean, I would like to know what the options are. What's gonna what are going to be the options? Because right now, April and May rent is not fully paid. So and it's kind of been an ongoing thing with her. It's we started in September, and yes, she once we filed in for eviction is when she started becoming responsive and making payments. But I just don't want to
be in the hospital for a month. I died on the operating table 3 times due to sepsis. But I'm sorry.
All right, look, couple things. First thing is, she's paid up through then March, correct? You're muted again.
Correct.
Okay, so she's paid up through March. It's April and May. There is I call it a division, but anyway, part of the housing programs here in Washington that will look at and try to assist the defendant in sort of working through the process so that she can get recertified, so that whatever the holdup is on the inspection, so that all of that can be accomplished. And I think what I'm going to do is refer her to that. Ms. Wilson, would you like to work with those folks?
Yes, please. Please.
All right. Now, I'm going to explain this to both parties, and particularly to the plaintiff. I'm going to allow your case to be reopened. I think part of the thing that you should look at, ma'am, is that a lot of times some of the difficulties that may occur with a voucher are not related to the tenant. You may think that it is. You may contact Section 8, and they may say that it is the tenant doing something. I've been doing this for years on end, and particularly right now. And when I asked who administers her voucher, I can tell you there are issues with that group. So, while I don't know for sure, this indeed may not be Miss Wilson's fault. If it's not Miss Wilson's fault, so that you can get this into your head, I'm not going to allow her to be punished for what may be the actions of a bureaucracy that she has to try to wind herself through, which somewhat has people who can't even do that bureaucracy right. And they will tell you things, they'll tell her things, and sometimes they'll even tell me things. So we're going to try to work it through. So,
thank you so
Amy,
much.
if she's referred over there, how much?
I did an updated email and phone number. What I see here is not this year. So
Pardon?
I just need an updated email.
For me,
Okay, Miss Well, hold on. I don't want you saying it to the whole world, because then goodness knows who'll be emailing you. Do we have her email? Well, Ms.
Your
Wilson,
Honor-
do you know how to use the chat?
I do not.
Okay, what's it
hardly got
start?
unmuted.
Well, what's the provider?
Gmail.
Ms. Wilson,
Yes.
is the Gmail address the good one?
That is correct.
Okay. Then you don't have a problem with us turning that over to Amy, do you?
Not at all. She's more than
okay.
I would love that.
Your Honor, is there any way that, I mean, she can at least pay her portion of what she's supposed to pay for April and May? Or, I mean, at least April something?
Well, here's part of the problem with that. What's her portion?
Haley, I think your portion just recently changed, correct, for May?
$610 a month. Correct.
I'm sorry?
$610 a month is my portion. And
when did that change?
No, 610 has been, that's the same one. I thought that you said your portion was going to change again.
No.
That's the reason I'm asking. Okay, so $610.
But like I said, I mean, that's what I was filling. That's what I had filled the SER out for, as the judge had asked, told me that that was an option for me last time, and you didn't get back to my caseworker, so she had to close it.
I have not received anything.
I sent you it as well, but okay.
You know what? If you guys want to fight, I can just leave you alone, and I can just. I
No,
got other
please.
stuff to do.
I'm so sorry. I just like Amy, if I can. I mean, I apologize, Your Honor.
Okay, so Ms. Wilson, do you agree that your portion is 610?
Yes.
Do you have the 610?
No, I do not. Not till the 17th. And like I said, I mean, my caseworker, they were going to help me through DHS. I mean, get that caught up so I wouldn't be in this bind.
I know, ma'am, listen. Right now, then, there's 2 months of that portion owing. Is that what you have, ma'am?
Are you, if you're asking me, yes.
Okay. Ms. Wilson, do you agree, based on at least the last recertification, that there would be $1,020 owed by you?
Yes, that is correct.
Okay. So now come the 17th, what will you have?
I will have half of that. I will be able to just catch up on 1 month because somehow in my paperwork, I thought that 1035 was out of the like $4,000 that I paid in the past month and a half. I somehow thought April's was in that amount. However, I guess it's not. So that's my.
So through all of that, you're going to have $610?
Correct.
On the 17th?
Correct.
Okay. So what I'm going to indicate is defendant to pay $617 or $610 by the 17th.
Got it.
Of May, okay?
It will
Now
be
that's going to be at least the April payment. Now I'm going to warn both. I'm going to warn both of you this. Well, Ms. Wilson, did you send in paperwork regarding your recertification?
Yes, sir. And I've also got the email from my CMA caseworker that stated that they have received it, that everything has been turned in, and that the payments for them would be reinstated effective immediately. And I like I said, I've got an email from.
Okay, I hear you. Okay. I'm just trying to make sure that your portion didn't change.
No, until my daughter has her third baby here in September, I think I'll be the same. I said until my daughter has her third baby here in September, the amount will still be the same because it's still the same dwelling because they all live with me.
You pay that. You'll have somebody from OCD Hawk send you. You'll be getting an email. You need to follow the instructions on that email and contact.
You said it's going to be through Hawk? Is that,
Well, it's gonna come from you.
okay, I just want to make sure, if I check for spam, like the emails sometimes don't all come through, so.
Okay, just look out for the email, follow the instructions. Got it?
You got it. Yes.
Okay, now I'm just gonna warn both of you. You get the 610 in. The problem for the plaintiff is this. I don't know how quickly I'm gonna bet part of the logjam in all of this rests with CMA, doesn't rest with the plaintiff, doesn't rest with the defendant. And so it's going to be having the individuals from the county sort of unblock that for both of you. So both of you are going to have patience. All right? Now, if you come here and you don't have patience, then I just won't hear anything. And you guys can go be impatient someplace else.
Judge, I would just ask, can we have a status hearing or something just to make sure that there's some type of progress on everything? I just don't want this to sit and months go by and
well, when am I gonna? I haven't given you a date to come back yet, ma'am.
I was just respectfully requesting a status hearing. That's all.
Okay, I've been doing this about 25 years. I know how to do it. I get it. Amy, if they start working on that, what are our averages of trying to get through with CMA? Is there a feel for that?
2 weeks.
2 weeks out? All right. So you pay on the 17th to 610. I'll adjourn this matter to May 24th, 2024 at 3 p.m.
May 24th, 3 p.m. You got it, and I'll have that in by next
The
Friday.
motion to reopen the case is granted. We'll see you then. Thank you.
Thank you. Appreciate it, Your Honor. Have a good one.
Court does call the case of the people versus James Whitley.
Good afternoon, Your Honor. For the record, my name is Jeffrey Bennett. I'm here with James Dennis Whitley.
This is people's emergency motion to modify bond in this case.
Your Honor,
Yes, sir.
I didn't file a response because we got this at noon yesterday. But honestly, we also yesterday afternoon received a discovery which we filed over. There's some issues that I certainly have with the allegations contained in people's motion. The simplest one is under paragraph 8. It lists 4 offenses: criminal history, A and B are the same offense. 22821 is a district court case that became a felony, was found over reporting registered actions, resulted in a plea to operating law, the second offense, 31621. So that is one. That's the minor issue I have. Their description of what happened on this day contains, I think, some confusing statements. Paragraph 3, they say that the children saw the witness the assault, but in paragraph 5, they correctly state 13-year-old son heard some screaming, glass break. He went into the room and observed the defendant sitting on the victim on the floor. The daughter, who was either 10 or 11, the brother thought she was 10, mom says she was 11, said that as soon as he got his car keys, he left. What I think this comes down to, quite honestly, in my cursory review, my assistant has looked in a lot more detail at these things. The statements contained in the police report are not 100% consistent with what the allegations are here as far as the case is charged or not. When he first asked whether or not he strangled her, she said, I will tell you that I will say that if you tell me I have to. This is not the case that they purported to be. This case is more consistent with what I explained as Judge Fink on Monday.
Magistrate Fink, but go ahead.
What's that?
Go ahead.
This Fink, did I say Mr.?
You said
Judge, Magistrate Fink, I'm sorry. You're all your honors to me. So, I don't want to get too much into the case, but what I will say is there are a huge huge numbers of inconsistencies between what the alleged victim said throughout her interview. This is, again, as I represented on Monday, I don't think there's much of a chance of conviction here. I will tell you that she is here. She wrote a letter to you. I've given a copy to the prosecutor's office. I will indicate, just for the record, I explained to her that I wasn't comfortable talking to her about what happened, because my belief is she may need to talk to an attorney. I believe she is supposed to talk to one on Monday. But she wrote a letter that explains how little afraid of Mr. Whitley she is. It's also not contained in the report is the report says that she called, the alleged victim called the police, and actually that her friend Michelle called the police. Michelle's known Mr. Whitley for 20 years. And her statement to the police was, Mr. Whitley is not like this. I've never seen him mad. He's always has a smile on his face. Stunned that it happened. The children said, don't hear him argue. Never seen her do anything before. Never seen him do anything before. Mr. Whitley is not a threat to the community. We look at the factor of the likely sentence. This, I initially had scored it as 0-17, but then when I looked at his record more accurately, because of the 10-year gap rule, he's going to be in grid B12, which is a 0 to 11 months intermediate sanction. It's a Class D felony. I scored for the injury to her, and I scored, which I don't agree with, but it'll likely get scored, that he exploited a domestic relation. B2, 0 to 11 months probation. And the people are asking not for a bond to secure his presence or to protect the community. They're seeking a bond that's punitive. They want to punish Mr. Whitley for what they think he did, which is not what happened, which I'm greatly looking forward to a trial to demonstrate, if they can even get her to testify to proceed. This bond was appropriately set. I guess I'll just go over what I went over with Magistrate Fink. Criminal record, 3 prior misdemeanor convictions, 2 of which exceed the 10-year gap rule that we use in a felony. Guideline scoring, all for operating while intoxicated. It's always showed up. The only history of substance abuse or addiction is what is related to alcohol use. Certainly he has had issues with alcohol in the past. He has no mental condition. It's not diagnosed. It's not dangerous. Also, what I just said in relation to the seriousness of the offense, presence, or absence of threats. And Wilson's trauma mentally. He has had no contact with her since this incident happened. He has been exceedingly proactive. My legal assistant has been in contact with the officer in charge since this happened. The day that it was indicated that the complaint was authorized, she tried to turn him in. Last Thursday, warrant not entered. Last Friday, warrant not entered. Monday at 8:30, warrant not entered. She gets notification that she shows up just a little bit after 10 o'clock with Mr. Whitley because the warrant was finally entered. So he is looking forward to defending what happened here because these charges are not what the people allege. He's an employee, he works 50 hours a week with daily infrastructure. He just told me that company was bought out. That's the old company. Yeah, it's in transition. He does have a daughter in the area. He has 50-50 parenting time with her on paper. She's 14 years old. She doesn't always like hanging out with dad because he has rules in his house. But he does have a child here he communicates with daily. His friends are here. His job's here. He has no ties to any other community. As I said, as far as the other thing, he's been proactive in turning himself in. And he's not had contact with the alleged victim. I have a stack of emails to him. I don't know how many emails. I'm sorry, Facebook messages, probably a quarter of an inch thick. She's sending him. I love it. I love it. All of these things. This is my fault. You only sent a text, a Facebook message to somebody else. I only got injured because you were protecting yourself from me. Again, I don't know what the true facts are. This is so new. What I do know.
Did he go to the hospital?
What's that? No, but I do have a photograph of his head split open from something that she threw at him, most likely a phone based on her statement to the police. It happened before these other things. She denied being strangled. She said that her head hurt, not because of an injury, but because she was confused. Quite honestly, I think it was more that she was intoxicated. She did admit to drinking. She may have been less than honest about whether she drove intoxicated or not. But at the end of the day, quite honestly, Mr. Whitley's not a danger. He's an upstanding citizen of Washington County. The prosecutor's office is seeking to punish him by $150,000 bond. It has nothing to do with what her allegations were at the time and nothing with what really happened. I don't see it here. I've only had, 27 hours to look at this stuff. The people have had longer than that. And I don't read anything in here, the people pointing out her own inconsistencies about what happened. And which affects, again, the likelihood of conviction. But it does just come down to, Your Honor, Mr. Whitley is not dangerous. He's going to show up. And he's been not dangerous his whole life. He's 43. This is the first time he's been alleged to have committed any act of violence against anyone. He has custody of a daughter, so the mother has it. She's never made allegations of domestic violence in the past because they didn't happen. So if I read the motion, it seems to me that the biggest focus is about his dangerousness. Jennifer's sitting right in the hall. She'll come in and tell you she doesn't consider him a threat. Again, if the court's willing to look at it, I can show you this letter that talks about her relationship with him and the fact that she's not afraid. Didn't ask her to write it. She just wrote it. I think she would also tell you that Michelle said that Mr. Whitley, that this behavior was inconsistent with who Mr. Whitley is, based on a long-standing reputation of not being dangerous. I ask that you leave the bond as it is.
Your Honor, I think what this ultimately comes down to is the people are very concerned for the victim in this case. I'm concerned that she's writing a letter. I'm concerned that she's saying that this is her fault. I'm concerned that she's saying that she provoked this in the form of throwing something at the defendant. To me, those sound like very telltale signs of someone in a domestic relationship who has been victimized previously. I think here, what we have is a woman who ended up in the ER, receiving 3 CT scans in the head and face area, 2 X-rays, one for the chest and one for the wrist, who had 2 kids who were around when there was a domestic dispute between her and her partner. And I think it is extremely concerning to me that the fact that when the victim said she had head pain, defense counsel characterized that as a symptom of her intoxication. It was explicitly stated in the police report that the defendant ripped her off the bed, slamming her to the ground, during which she landed on the right side of her face and was unsure if she even lost consciousness at that point. That seems to be the root of why she would have gotten the CT scans, being concerned for a concussion. The victim also sustained multiple visible injuries, including cuts, bruises, red marks on her upper body and her neck. I think that count 1 on here is charged in the alternative of assault, TBH, and or strangulation. We do not need to prove simply strangulation in order to proceed on the felony here. We can proceed on the assault, TBH, which I do believe would be satisfied based off of the victim's requirement or required medical treatment as a result of this encounter with the defendant. Ultimately, I believe that the PR bond here is an abuse of discretion. And we did make an argument at arraignment for the $150,000 bond in this case, and I would be renewing that request today.
I may reply, Your Honor, briefly. I make it clear this alleged victim was previously the victim of domestic violence from her deceased husband. That can explain maybe some of her reactions, some of the issues that she had.
What does that mean?
Her children, and she said this had never happened before by Mr. Whitman. Never happened before. Okay.
But I don't understand the first part of what you just said, how that relates to this.
She may have some PTSD related to the trauma before, but that doesn't mean that what Mr. Whitley says happened is wrong, or what how she answered the question. The first, and quite honestly,
Mr. Bennett, I'm trying to figure out what you mean by some PTSD from before. You're saying her reaction to all of this is in reference to some PTSD because of stuff that happened previously?
The prosecutor is making some comments that are speculative about her being a classic victim of domestic violence, which she was in a prior relationship. So the fact that the prosecutor sees that is unsurprising. That's what I'm saying. And as far as that he ripped her off the bed later at the hospital, that's not what she said. She said they fell off. I don't know. I don't know what she's going to say in the statement. And what's important about this, no influence whatsoever by Mr. Whitman. He has stayed away from her. He doesn't want to interfere with what she believes happened. And he's not trying to influence her to do anything. I find it surprising that they're alleging that she's in danger, the prosecutor, and they don't call her to show up. She reached out to a friend of my client's.
Call her to show up to do what?
Today, to say I'm afraid. I mean, I will say.
Mr. Bennett, you've been doing this long enough. You know that's not going to happen.
I don't know, at 3 o'clock with 24 hours notice, I couldn't have got a hearing in that.
Could have got a hearing on what?
If this was reversed.
Absolutely. Oh, do not even insult this court by saying that, Mr. Bennett. Do not, because you would have gotten a hearing. Had you filed a motion, had you requested that it is an emergency hearing, the public defender's office does it all the time. The fact you don't know how to do that and think that this court is playing favorites, you're wrong. The court's going to stand in recess.
Right. 14A District Court for County, Washington, session, the Honorable James.
You may be seated. Court recalls the case of the people versus Whitman.
Good afternoon, Your Honor. For the record, my name is Jeffrey Bennett. I'm here in this time to help Mr. Woodley is standing to my right. Will you state your name before, please? James Dennis.
Let me just say this, Mr. Bennett. I've been on this bench almost 25 years, and never have I ever been insulted in the fashion you just insulted this court.
Why?
No, my turn. The very first case, when you say that defense counsel or anybody else doesn't get access to the court like the prosecutors, you are absolutely wrong. The first case I called today was upon receiving a notification about something that I had considered in a bond, was notified that that had been located. This court, to the defendant's benefit,
set that hearing without notice to any side. I set the hearing. So to be fair to all of the parties, I receive motions all the time regarding bond. And this court just seeks to be fair, to have a hearing. Mr. Bennett, if I had had in my heart the desire just to lock your client up, quite frankly, because the decision came from a magistrate under the court rule without a hearing, I could have changed that bond. But I wanted to give the parties the opportunity to be heard. Now, having said that, so maybe you can put that in a little perspective. I heard you that you said you just got the discovery, can't go through it. Well, I'm going to give you about another 18 hours to go through it because I'm adjourning this hearing for two reasons. To allow you to go through the discovery, to give me a cogent argument as to why I should not grant what the people want. And secondly, because you have raised the ire of this court. I am not going to punish your client by what was one of the most ignorant statements I have heard about the conduct of this court from any counsel in all of my years. I will not, by any means, punish him for that. I do not make my decisions out of anger. I'm adjourning this to tomorrow, May 10th, noon. All the parties are ordered to be here. That is all. That is all. Noon tomorrow.
Are you kidding me?
Oh my God.
You have got to be kidding me. What is going on today? This is a joke. This is a joke. Today is an absolute joke. He needs an interpreter.
I need an interpreter when I cannot express myself sometimes.
Joke. Oh my God, sir, put that cigarette out. I don't give a crap that you are outside of this. What is wrong with everybody today? You know what, Miss Reed? We're going to start bringing people in person. People are going to learn how to act in a courtroom.
Can you hear it? Can you hear it? Ma'am? Ma'am? Can you hear it?
No, I'm not.
Okay.
I have no patience left. And trust me, out of the day, I'm sitting up here, I'm the one that needs a drink.